Welcome to Off the Record, a legal podcast.
Hello and welcome to Off the Record, a legal podcast with attorney Rhett Burney. With years of experience in family law, personal injury cases, and estate planning services, Rhett and his team are well-versed in providing top-tier legal representation for individuals across the great state of South Carolina. I am your host, Kevin Rosenquist, and today we're going to talk about mediation versus litigation, choosing the best path for divorce in South Carolina. Rhett, great to see you again.
Great to see you. I thought we were talking about how to commit the perfect murder.
Oh, we really are? You really wanted to do that?
Well, you're the guy. We'll talk about that in the next one, maybe. So okay. Mediation.
Slightly different topic, but yeah. Mediation.
We'll talk about murders next time.
Okay, sounds good. So what exactly is the role of mediation in divorce cases in South Carolina, and how does it differ from the traditional litigation process?
Mediation is required in South Carolina if you cannot work out your case between the two parties. And it's for all issues: custody, visitation, divorce, division of debts and assets, alimony. Probably left out some things. So before you can even have a trial, you have to go through mediation in South Carolina. And so what the process looks like: a mediator will be appointed. Both parties usually appear at somebody's office. One party's in one room with their lawyer, the other party's in their room with their lawyer. And the mediator, who's skilled in negotiations, goes back and forth, discussing and negotiating those issues that the parties have between them to try to find a common ground. I would say most of our time these days is spent in mediation, less time in trial. Mediation is very, very effective. I would estimate 85 to 90% of cases get worked out in mediation. It's a very valuable tool, saves clients lots of money, saves them lots of headaches, and they keep control over everything. When you appear in front of a judge, it's a crapshoot. That judge is going to make a decision, and there's nothing you can do to change that decision. But in mediation, you get to be very creative. You still have control over it, because in mediation, it only works out if the parties agree to something. It's not like arbitration. With arbitration, you have an arbitrator and they make a decision, much like a judge. Mediation, the results are provided or reached by the parties themselves during the mediation.
It's almost like they get suggestions from the mediator to kind of help resolve the case, but ultimately it's up to the parties to decide what they want to do.
Yeah, they've got to come together and say, well, this is what we want. And in mediations, sometimes we work out everything. Sometimes we work out parts of a case. There's nothing wrong with that either. If you work out parts of the case, then you go to trial on the other.
It makes sense that would be successful, just because, especially in this day of texting and emailing and all that we get fired up and we don't really understand tone and we don't understand intent. And when you finally sit down and talk about it logically with somebody helping you along the way, almost in a therapeutic sort of way, to help you kind of like come to an agreement, it makes sense why that would be effective. Yeah.
And sometimes it's the first time people actually feel heard. When you go to a temporary hearing, you're just submitting affidavits to a judge. Parties don't get to talk. In mediation, they get to talk. It's not a mini trial. We've bypassed all of that. The mediator wants to know some of the facts, but it is, and it helps. Communication is the key to everything, right? So while we're in mediation, it really fast tracks the discussions between the parties and the lawyers. Because Kevin, as you can imagine, if you and I are lawyers and we're representing clients, I call Kevin and say, "Hey, Kevin, my client wants to do this." You say, "Great, Rhett, let me call my client." Well, you may get your client that day or the next day or whatever, and then y'all talk, and then you call me, and then you may get me a day or two later, and then I get in touch with my client. We've got one issue resolved. In mediation, we're all there, usually in the same building. We do video ones as well, but usually we're all there. So the communication is just sped up immensely. And it's funny, lots of mediations, we find out that people were never that far apart. They just never had a chance to discuss it. And for the first time ever during the mediation process is where we find the lightness of minds.
And maybe your guard goes down a little bit, and the hill you're ready to die on maybe becomes a little less appealing, and you're willing to work together.
Sure. And mediation, it doesn't happen. A case is filed. Mediation usually happens, we'll say 6 to 9 months after the case is filed. Sometimes sooner, sometimes later, just depends upon the facts. So by that time, things have kind of settled down. When people bring a lawsuit for divorce or custody, it's kind of like a nuclear bomb goes off, right? A huge explosion. Everybody's running around and just scared. And as time goes by, when that fallout settles, the emotions settle, clearer heads have come about. And usually by that time, people are seeing things a little bit clearer.
Did you say that mediation is required?
It is required in South Carolina. It is.
Okay.
Sometimes it's waived, but for the most part, you have to mediate because it's successful. Like I said, it's 85 to 90% success rate. And without it, it would take years to have a trial if we didn't have mediation.
Are there situations where someone can be like, yeah, I don't want to sit down and talk about stuff with them. I'm not going to do it. Or do they is it like, no, you have to show up for this?
That's exactly what. So you have to do it.
Wow.
I'm a mediator. I mediate lots of cases for other lawyers. And I can't tell you how many times I walk in at the very beginning of the mediation. The other side says, we're never going to come to an agreement. We can't do this. We're not going to do that. And we get it worked out. Right. Yeah. Lots of people say they can't do it, won't do it. You have to do it. And usually it's successful. It is worth a shot, saves a lot of money because otherwise you're looking at thousands of dollars of having to go to trial.
Right.
Mediating for a day, it does seem expensive, but not like a trial. Trial is much more expensive. And you run a lot of risk going in front of a judge who there's no guarantee. Judge may not like you that day. You may not come across well to the judge that day. Every judge has their different likes and dislikes. So when you're mediating your case, you do keep that control. So the mediator's not making that decision. You are. So very useful tool.
In a situation where they can't come to an agreement, mediation's over, didn't work. What happens next?
Yeah, then you go to trial, unless that murder happens. Sometimes that does happen, but next you go to trial, and trial is a couple of months away from mediation. And the hardest part about a trial is the preparation. The trials for lawyers, it's fun, but we probably spend 3 to 4 hours for every hour of trial that we're going to have just preparing for the trial. Because you have to be prepared for everything, prepared for every contingency. You don't know what the other side is going to say. You have to go through all of your exhibits. So once we get to the end of a mediation and we know we're having to go to trial, we talk to the client about, hey, you've got to have a trial retainer. Hey, we need to get all these documents together. Hey, you need to make sure you're not going to be on vacation or out of town. Hey, we got to get your witnesses. We got to subpoena them. A lot goes into that. It is not easy like you see on TV. It's all the things happen behind the scenes, the preparation of it. It's very intense.
Mm-hmm. I'll bet. And does the judge have access to like a transcript of what happened during mediation if it goes to trial?
Yeah. So fortunately, everything that happens in mediation is confidential. The mediator cannot be subpoenaed. No one can be subpoenaed to testify about what happened or what was said during mediation.
Okay.
And the reason it's confidential is because you have to have a free flow of information between the parties, right?
Right.
And if somebody is afraid to offer something or to say something because it would be used against them later if they don't get it worked out, nobody would ever say anything. You wouldn't get anything done. Mm-hmm. So the only way the judge knows what happens in mediation is if you have an agreement, because typically we type up the agreement while everyone's sitting there and you present that to the judge on your final day that you go in front of a judge for him to approve your agreement.
Okay. Gotcha. So it's not like the judge knows why mediation didn't work.
Yeah. No, they have no idea. They have no idea.
Yeah, because I could see that being it could create a bias too for the judge.
Oh yeah, absolutely.
One person was acting like a jerk, then they could, they can use that against them.
Usually that comes out anyway.
You mentioned the word arbitration before. Is that an option too, or does that not really play into this much?
No, we arbitrate some things. Usually when we arbitrate, we can't arbitrate any child issues in South Carolina anymore. We can arbitrate property issues. We can arbitrate alimony issues. And that's not a bad way of doing it either. Usually when we do the arbitrations, we'll use a lawyer or a retired judge, someone who is skilled and knows family law, because sometimes the issues are just so clear cut that there's not a lot of gray. And all we need is just someone to make a decision. And you may have one side who's just stuck in the mud about it, just won't agree to anything. But the issue is so clear that a judge may order you to go to arbitration, or the lawyers may just say, hey, let's go to arbitration. We know what's going to happen. Let's just get it done and put it in front of a judge, in front of an arbitrator who acts like a judge. They make a decision that will be binding upon the parties. There's some of the benefits of arbitration. Typically, you don't have to prepare as much because usually by that point, the facts are a little bit more clear. And you get to control when you're going to go to to your arbitration, when you have a trial, you don't get to control when that trial is going to occur. You're told. Arbitration is typically cheaper because you're not having to prepare as much. So there's some benefits to arbitration as well.
You mentioned that you're a moderator. How do you, I don't know, how does that transpire? It's like you got to feel like kind of like a marriage counselor or sometimes, or a therapist or something, right? I mean, it's got to be a unique situation to be in.
Yeah, it's fun. I've been doing it probably 15 to 20 years as a mediator. You learn what to do and what not to do. Communication is the key. And again, people want to be heard.
Right.
There's some great books out there, Never Split the Distance by Chris Voss, that talks about negotiation skills, the psychology behind it. There's a lot of psychology.
I have that somewhere. Never Split the Difference. Yeah. I know that book. Yeah.
Have you read it?
No. It's my wife got it, and I have it here. I was going to read it. It sounds like I should, huh?
Yes, it's a great book. It's an interesting book, but there's a lot of truth to it. But yeah, sometimes people think that when you're in mediation, all the mediator is doing is just the messenger taking things back and forth. And sometimes that is true, but for the most part, a good mediator is going to have skill. There is skill in doing mediations. There is some people are good at it, some people aren't.
Do you prefer that over going to trial whenever possible?
Yeah. I think every lawyer would rather get a case worked out in mediation than go to trial, just because there's so much time invested in going to trial. And clients keep control over the outcome. And every lawyer will tell you stories where they've had great cases and lost them, and terrible cases and won them. And that's just the truth, because there's so many moving parts. When you're going to trial, you don't know. It's hard to make a prediction. If I were a heart surgeon, Kevin, I can predict the outcome of your heart surgery a lot better, a lot closer to the outcome than a lawyer can predict the outcome for your case. Because I don't know how your witnesses are going to sound. I don't know how you're going to sound. I don't know whether the judge is going to like you, whether the judge wants to be there that day. Is the judge listening? There's so many various factors, but in mediation, you're not having to worry about that. It's just the facts and the parties, and we roll with it.
And if it does go to trial, there's not a jury, right? It's a judge-decided situation?
Correct. Yep, just a judge in South Carolina.
So then I guess the difference between arbitration and a trial, you said arbitration tends to be quicker, but it seems like it's very similar though, right?
Very similar. Usually when I arbitrate with another lawyer, we meet ahead of time and kind of stipulate on the rules we're going to use, and it's a little more relaxed.
Okay.
If you're in front of a judge, you're protecting a record. And so you have to do things a certain way. But arbitration is a little more relaxed. You can still call witnesses. You can still present evidence. But if you have two good lawyers, they're not going to object every 5 seconds. They know what's going to come in and what facts should be heard. So I like it better I like trials, but arbitration can be very handy in certain circumstances.
I know you said mediation is pretty high percentage of success. How often does it move all the way to trial and not even do arbitration?
Yeah, so we have to do mediation first, and then with the trial, if we don't get it worked out, then we go in. We'll have a trial if we don't get it worked out in mediation. I mean, we have lots of trials, but nowhere near the amount of mediations. For lawyers, we're in mediations practically every single day because of the caseload that we have. So if you look at a typical lawyer's scheduling, you're going to see 10 to 1, 20 to 1 more mediations than trials. I think it may be 50 to 1, just because they are so successful.
Are there situations where the people involved are worried that a mediation isn't going to hold up the same in court because it didn't come from a judge?
Yeah, but we get through that, because ultimately they will be in front of a judge with a mediation, because it has the mediated agreement. Let's say people will show up at a mediation, they come to an agreement, it's reduced to writing, then you present that in front of a judge at a later date, and that judge will take that mediated agreement, the parties' agreement, make it a court order, so it will be upheld just like any other court order. It will be upheld the same as a court order that may be issued from an actual trial, has the same amount of weight. Are
there certain cases or certain types of cases or situations where mediation isn't technically a good option?
Yeah, like a termination of parental rights. If you're trying to take someone's parental rights away, there's not much middle ground there. Take them away or you don't. Adoptions, we don't have to mediate that. unless they're contested. But for the most part, every case is primed for mediation. And when we have the kickback from clients who don't think it's going to work, well, they've never been through mediation. We wouldn't have it if it didn't work. So, that conception that only a judge can make a good decision, that's false. There's nothing magical about a judge. We have some very smart people on the judiciary, but all in all, they're regular people. They were lawyers at one time too. They make mistakes. They don't pay attention sometimes. Not every judge is like that. We have some great ones. But for the most part, if you can avoid, I tell my clients, if you can avoid a trial, do it at all costs, because otherwise it can be a crapshoot. It's very unpredictable. It just is.
Yeah.
It just is.
All right. Well, thanks for tuning in to Off the Record, a legal podcast with attorney Rhett Burney. For more information or to connect with Rhett, you can visit rhettburney.com, and be sure to like and subscribe to our channel and leave us a review. Rhett, thanks so much for talking mediation with me. Next time, planning the perfect murder.
Planning the perfect murder, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.